In the late 1950s, the United Nations started a process to decolonize territories that were annexed during the European scramble for territories in Africa and the world at large. And this was agreed upon during the United Nations Charter Resolution 1514, in which the process of decolonization started. But by 1960s, the United Nations fast forwarded this decolonization process by coming up with a committee to look into decolonization of territories across Africa and within other continent that had been annexed by European nations as far as the Berlin West African Conference was concerned. In this effect, under the UN Charter 1514 on the decolonization, on granting of independence to colonial countries and peoples across the world, in Resolution 1514 adopted by the General Assembly, in paragraph 9, it is stated that believing that the process of liberation is irresistible and irreversible, and that in order to avoid serious crisis, an end must be put in to colonialism and all practice of segregation, discrimination associated therewith. With this context, the United Nations Resolution 1514 also pointed out key aspects in which this can be done. It was further segmented in Resolution 1608, where the United Nations General Assembly articulated the process under which countries within the trusteeship and those non-self-governing countries will have their independence. In all of these, it is still not clear whether the decolonization process actually achieved its desirable goal across African continent, and with that in Cameroon in particular, which is our focus, if actually this decolonization process achieved its goal, and if it did not achieve its goals, what must be done by the United Nations organization in order to understand that crisis within the Northwest and Southwest region could partially be put on their table and be brought as part of their problems created either directly or indirectly as far as the decolonization process is concerned. However, there is a school of thought that is clear on the fact that the decolonization process succeeded effectively in Cameroon, in the Northwest and the Southwest region. Quoting allegiance to the UN Charter 1508, UN Charter 1514, which pointed out point 6, which pointed out the fact that there is the termination of the British mandate ended with the voting of the British Southern Cameroon and the British Northern Cameroon. Another school of thought states that that was poorly done and not well established, and that there is a need for the UN to re-establish what it started under Resolution 1608. There is another school of thought that states that we must build a new Cameroon that will not be based on the colonial past, a new Cameroon that will be based on the people from Northwest and Southwest region coming together as a force to meet the people of the East Cameroon to form one Cameroon that will be based on a diversity, unity, on a new frontier that will have to keep away the Southern, the Northern, but we look at Cameroon as the people which share identity, culture, and tradition. In all of these, the question we are asking now is, 1961 1st October, was it unification or reunification? Was it unification or reunification? Or some say assimilation? All these and yours will be on House of Commons with me, Tamai Jarvis. You're welcome back from that transition. If you are just joining us, you're watching House of Commons. To begin the program, I introduce to you my guest with whom we are going to have a 1 hour 30-minute discussion as far as this topic is concerned, and we are going to look at it from an educational perspective and not from a political perspective, and also a legal perspective. I invited legal minds here in the studio. I initially sent invitation to Barrister Nkea Emmanuel, who promised to be here, and also I sent out an invitation to Senior Barrister Ashu Emmanuel, who also is already in the studio. I also sent out invitation to members of the civil society organization, those who actually are representing the people on the ground, to have an understanding as far as their views is concerned, so that we can have a balance, as well as a member of the Cameroon's People's Democratic Movement who is here to come. And also this is to give a fairness, balance, accuracy as of what we shall be discussing today on our program House of Commons, where we shall be looking at understanding the legal implication of Resolution 1608 within the context of Southern Cameroon as first topic. And the second topic we shall also look at, is it 1st October 1961 reunification or unification? Mr. Vitalis, you're welcome and thanks for joining us. Happy Sunday.
Thank you, Mr. Jarvis. Thank you, all the televiewers. It's my pleasure to be here, especially with Senior Barrister Ashu and my friend, Mr. Suleman.
Thank you very much for joining us. And also here in the studio, we have Mr. Suleman from Kumba, member of the Social Democratic Front, a bona fide member who believe that the party must be given to the people that can best represent Cameroon and unite Cameroon in their diversity. You're welcome, Mr. Suleman from Kumba.
Yeah, hi, Jarvis. Hi, my co-panelists. Hi, our televiewers outside there. We have again convened at the Studio 1 of my Media Prime to discuss some of the issues affecting our country and our society.
And also in the studio, we have the president of the Reform Party, who has a view that the Cameroon problem shall only be resolved if the Reform Party is voted, because of their manifesto, which seek to unite Cameroon and respect the bicultural nature of Cameroon, and ensure that power is given to the hands of the common man, and that those who are found guilty of embezzling and stealing state funds are brought to justice, and believe that the law should be the law, and the law should be amended to meet the aspiration of the common man, providing social and economic justice across the nation as a whole. However, he is firm on the fact that we must not erode history, we must not try to distort history, and that when we learn from history, we can build a nation that will be united in its diversity. Senior Barrister Ashu Emmanuel, President of Reform Party, happy Sunday.
Thank you, Mr. Tamnjong. Happy Sunday. Special greetings to all the members and sympathizers of Reform Party, all the Cameroonians and televiewers as a whole. I hope we're going to enjoy the debate.
Thank you very much, Senior Barrister Ashu, for joining us. We await the present arrival of Barrister Nkea Emmanuel, or the two Emmanuels. So we're hoping to have him. The topic for today, the first topic, we are looking at understanding the legal implications of UN Resolution 1608 within the context of Southern Cameroon. To begin with that, I'll start first with you, Senior Barrister, to look at this issue, since you are a legal mind. And let us first of all look at, I'll give you a preamble as to where I'm coming from. Then now I'll ask you my question. 1514 UN Charter that was adopted, laying down the framework of decolonization process. 1608 came in and established the decolonization process. Sub 2 of 1514, UN Charter 1514 states that all peoples have the right of self-determination by virtue of the right. By virtue of the right, they freely determine their political status, freely pursue their economic, social, and cultural development. Sub 3 of Resolution 1514 states that inadequacy of political economy, social, and educational preparedness should never serve as a pretext of delaying independence of its country. Sub 5 of Resolution 1514 states that immediate steps shall be taken in trust and non-self-governing territories or all other territories which have not yet attained independence to transfer all powers to the people of those territories without any conditions or reservation, in accordance with their freely expressed will and desire, without any distinction of race, creed, color in order to enable them to enjoy complete independence and freedom. Now, very important, sub 6, which many are stating that this is the premise where Cameroon government has a clear case and to win. We state that that is resolution 1514 before coming to 1608. It states that any attempt aimed at partial or total disruption of the national unity and territorial integrity of a country is incompatible with the purposes and the principles of the Charter of the United Nations. To this effect, therefore, I put it to you, Senior Barrister, when we look at the resolution 1608, which I shall be moving down to sub B, 1, 2, and also 3. If we look at this, can we say the UN is itself confused legally?
Thank you, Mr. Jarvis. I think we have to understand these international law instruments that you're citing, because when you talk of UN resolutions, they are international law instruments. Now, to understand them, 1514 is the instrument that laid down the general principles of decolonization.
Yes.
1608 is particular to the Cameroons. It's the independence vote for the Cameroons. It doesn't concern other territories, like I heard some person misstating. 1608 is only for the Cameroons. It concerns nobody else. So you cited sub 6 of 1514, and you wanted to know whether under that one you can apply, whether you can take that one and apply it to the case of Cameroon.
Yes, where many Cameroonians are stating that the UN has finished its business.
I want to remind you that that was a principle governing decolonization. It was one of the principles governing decolonization. All right, so you cannot take it now and apply it to independent nations. It is, I mean, they mean that a country that has already been given, granted its independence, everything, you don't, it's in line with the Charter of the United Nations. You don't have what Russia is doing in Ukraine. I mean, that's just the same thing. They go to Ukraine and they want to annex. So this is the same thing they're talking here. Now, when you come to 1608, they will tell you at law, specialia generalibus derogant, special laws are applied in preference to general provisions. Now, 1608 being the provision that is specialized for the Cameroons, takes precedence. Now, I heard you mention some, I think what is Article 2 or so,
yes,
of 1514.
Yes.
People should not get confused.
Let me read it again so that you analyze it. The Article 2 of 1514, Resolution 1514, states that all peoples have the right to self-determination. By virtue of their right, they freely determine by virtue of their right, they freely determine their political status and freely pursue their economic, social, and cultural development. Yes,
that was exercised in the Cameroons on the 11th of February 1961. That was exercised. Now, I'm talking about the provision where you said the decolonization process was over.
Yes.
Right. I want to refer you to 1608, Article 4, if you have it there.
Yes, I have Article 4 of the 1608, which states that decided that the plebiscite having been taken separately with different results, the trusteeship agreement of 13 December 1946 concerning Cameroons under the United Kingdom administration shall be determined in accordance with Article 76B of the Charter of the United Nations and in agreement with the administering authorities in the following manner. A.
No, leave it there. Shall be determined in the following manner. You see, it prescribes the manner in which the trusteeship agreement was going to come to an end. That is the important point there. You see, this provision determines in what manner the British trusteeship was going to come to an end. Now, when you continue to read Article 5, please go ahead and read Article 5. You will see that as of today.
Article 5. In Article 5, it says, invite the administering authority in the government of Southern Cameroon and the Republic of Cameroon to initiate urgent discussion with a view to finalize before 1st October 1961 the agreement by which they agree and declare policies of the parties concerned will be implemented. That was signed on the, that was during the plenary session of 994 meeting of the United Nations, 21st April 1961.
Thank you. So you see, the United Nations clearly stated the way, the modus operandi of the British trusteeship coming to an end. Now, as of today, do you have any evidence that there is an agreement setting down the manner in which they agreed and declared policies of the parties were going to be implemented? Do you have that? So it is the absence of that instrument which makes us say that the UN has unfinished business. They prescribed the manner in which the trusteeship was supposed to come to an end, but they never saw to it that which they prescribed was followed and respected. We have a country today that has no document prescribing the way and manner the people are going to live together. That is the problem. That's where it is.
Senior Barrister, I'll be coming back to you. Let me come to Mr. Suleman. Mr. Suleman, when we look at this quagmire, what is ongoing now, where many say the UN is not finished, some say the UN is finished, and others say we should come together now as a people and forget about the UN and forget about the British, which mandate, according to the UN Charter, ended after the plebiscite, that we should form a Cameroon with diversity. Where does the Social Democratic Front stand as far as this
I think,
up and down is concerned?
Before you go back, Article 1514, which you cited, you see, decolonization was generally meant for the entire Africa. Tanganyika, everywhere, Funa, Tanzania, all those things. But Cameroon has its own peculiarities. Self-determination, freedom, liberty was denied the people of Southern Cameroon. Because what? Because when you go to Article 1350, where the future of Southern Cameroon was to be determined through a plebiscite, under the General Assembly of the National passed wanted to know the future of the trusted territory of Cameroon under British administration, and they prescribed that the representative of the UN in Southern Cameroon and that of Britain should conduct a plebiscite. But they denied us independence because they removed that word independent, because they knew that we were not qualified for independence. But I think we were, as a sovereign country, we need self-determination, we need freedom, we need independence, to enjoy everything. But they denied us that one. They told us that no, we are not going to that level yet. They only gave us to choose two options, either to join Nigeria or to join the Republic. So I think, Mr. Davis, we the SDJ, we believe that the United Nations Assembly, the United did not do a good job for the people of Southern Cameroon, because they were supposed to actually allow us the third option that was proposed by Indele, Atimuna, Dr. Chimnyenchi, Ombachotai. All these were options that had even allowed us to go our way and to it allowed us to go our way to vote. I think we would have voted for independence and would have been self-defending. We would have been self-independent country today.
Okay, but now again, when we look at these, you talk about the fact that the UN did not grant us the permission. Many say that Cameroon was one and that the UN was merely uniting the country.
No, Cameroon was not one. Cameroon was not one. You have a Republic of Cameroon, you have Southern Cameroon. We were linked to Nigeria. It was as a mandated territory. We were under Nigeria. We even had represented at the Enugu under National Council, Regional Assembly, under National Council of Nigeria and the Cameroons. So we were not one. NCNC. So we were not one. We only became one after the plebiscite of 11 February 1961, when it was only a sham plebiscite. I call it a sham, but again, it was accepted because under the plebiscite we had British Northern Cameroons and we had British Southern Cameroons. 60% of Northern Cameroons voted to join Nigeria. 70% voted to join the Cameroon Republic. According to, but again, that one too, some school of thought are still contesting that because it was a sham. It was not properly done. It was manipulated, masterminded by Hugo and the French. So I think what we are saying, as far as SDs are concerned, is unacceptable.
Mr. Vitalis, you moved to the field in the Northwest and you interact with people from the Northwest and Southwest region, you are from the Northwest region. When we look at this quagmire of Resolution 1608, what is the view of the people?
Mr. Jarvis, why we are biting our lips today is because I can say we have a system in place that has not lived to the expectation of the people. Because if we had a system that had lived to the expectation of the people, we will not bother ourselves going back to history. Why we are going back to history is because the people are not satisfied. The people are not feeling the impact of the country in them. So that's why we have to go back to start looking at the foundation of Cameroon. Because when if you look at the agitation that is now, in the days of Ahijo, we didn't have this agitation because everybody was feeling like, I'm part of Cameroon. But when it comes to now, where we have a lot of crises, people are now beginning to question the foundation in which Cameroon is built. And that's where we have the problem now. But from the startup, I go to Northwest every day, and the view of the people is that nobody hates Cameroon, but people hate what they are going through in Cameroon. Nobody hates Cameroon, just that people hate what they are going through. If we have a system in place that gives justice, that gives equality, that the economy is booming, and that the youths are able to have jobs, and that everybody is living his Cameroon dream, I think we will not have to go back to start looking for the foundation in which Cameroon is built. So that's my own point of view. That
seemed to be the policy of Reform Party, because we were just speaking there, that was Senior Barrister Ashu was nodding his head that it means that his manifesto is on the right track, the Cameroon dream.
It's true. If we have the Cameroon dream, we will not bother to go back to history. Just because that deletion, people don't feel that I'm part of this country. I'm not enjoying the country as a citizen of this country. And I'm not, my dreams are not being met. So when all these things is put together, people are forced to agitate. And when they agitate now, they are forced to start looking back at the foundation. It's just like you build a house. If you build a house and the house is standing very strong and healthy and people are enjoying the house, nobody will question the foundation. But when the house is shaky, people now begin to question the foundation. That's why we have not to, most of the time people have to go back to decolonization, resolution, this, to see on which foundation Cameroon is built. Whereas if everybody was living well in Cameroon, nobody will have time to go back to start questioning history.
So you are of the school of thought that says that we should now build a new Cameroon where we shall live the Cameroon dream,
yes,
and not much looking at the history?
Yeah, because when you look at what is happening in Northwest, the war has been raging on now for 6 years, and the United Nations, in which we count upon so much, they have said nothing. So I think that it is time that we as Cameroonians to sit down and see how we can bring about the solution to our problems. Because we keep on depending on the United Nations. I don't think that one day they will ever come to solve our problem. The problem is us. Those who are suffering is us. It's not the United Nations that are suffering. It's the people of Cameroon that are suffering. So I think that if we have a system in place that is able to listen to the people of Cameroon